Hi, everybody. Thanks for joining us. I'd like to begin by acknowledging the traditional owners of the land on which I'm hosting this meeting today, the Wurundjeri people of the Kulin Nation, and I'd like to pay my respects to elders past and present. I'd also like to extend that respect to any Aboriginal or Torres Strait Islander people who are joining us today. My name's Ben Spivak, and I'm a senior lecturer and co-director of the Psychology and Legal Processes Research stream here at the Centre for Forensic Behavioural Science at Swinburne University of Technology. It's my pleasure today to welcome you all to the Centre for Forensic Behavioural Science's first seminar in our seminar series. The seminar series is a monthly event in which we host an expert in issues related to criminal justice and forensic psychology. We have a number of wonderful seminars lined up. Next month, we have Anna Charlton from the Sentencing Advisory Council, who will be presenting findings around the sentencing of stalking offences. And the month after that, we have Associate Professor Tess Neal from the United States, who will be presenting her research on expert evidence. We have a number of prominent domestic and international speakers lined up who will be presenting the latest developments in research. So if you'd like to be added to our mailing list to be notified of future events, please send me an email. Or better yet, send an email to info-cfbs@swin.edu.au. I'm going to place both of those emails in the chat. Okay. Today, I'm very pleased to be hosting Professor Lyria Bennett-Moses. Lyria is a director of the Allens Hub for Technology, Law and Innovation and a professor and associate dean in the Faculty of Law and Justice at the University of New South Wales, Sydney. She's also co-lead of the Law and Policy theme in the Cybersecurity Cooperative Research Centre and faculty lead in the University of New South Wales Institute for Cybersecurity. Lyria's research explores issues around the relationship between technology and law, including the types of legal issues that arise as technology changes, how these issues are addressed in Australia and other jurisdictions, and the problem of treating technology as an object of regulation. Recently, she's been working on legal and policy issues associated with the use of artificial intelligence, the appropriate legal framework for enhancing cybersecurity, and oversight for law enforcement intelligence. And that's what her talk will be about today. Before I hand over to Lyria, I just wanted to do a tiny bit of housekeeping. There will be time for questions in this talk, but you'll note you don't really have mics. So if you want to enter your questions into the chat, I will select the questions and put them to Lyria after the presentation. Thank you. Please welcome Professor Lyria Bennett-Moses.
Thank you very much. So thank you all for coming. I'm just going to probably start with a little bit on, what this paper is about and what it's trying to do. So essentially what it's doing and what I'll be talking about is, so it analyses the jurisdiction, function, powers and expertise of oversight mechanisms for police in Australia, New Zealand and Canada, with reference to the capacity to oversee the legality of police intelligence practices. And in particular, the reason for the comparison of three jurisdictions is what each might learn. So it's not about effectiveness of oversight, which is the next point there, which raises slightly different issues. But I wrote it because there's not a lot of literature on oversight of police intelligence, at least not outside the US. So the motivation for this comes as part of a larger project with collaborators also in New Zealand and Canada around intelligence-led policing more broadly. Intelligence-led policing, the idea is it's strategic, it's future-oriented, it's proactive, and increasingly police are employing crime or intelligence analysts, the terms vary. In some cases, these are civilians, not in every case, that depends on the jurisdiction. But generally speaking, one way or another, what these people do is they analyse flows of data to generate actionable intelligence that can be used in the prediction and management of crime. Is everyone still there?
Yes, everyone's still here.
Oh, sorry. Okay, I just got a really weird noise from my computer that made it sound like something had died. So sorry for that. Okay, so So it includes things like predictive policing. It includes a whole bunch of other technologies as well, and technology is kind of part of this story. So the part of the reason why police intelligence is becoming more important or more controversial is the kinds of technologies that are being used. So predictive policing, facial recognition, social media analytics, the idea of buying data from data brokers and so forth. And some of these things, and we can think of one example being the use by some police services of Clearview AI, which is a facial recognition program, are becoming increasingly controversial, with questions raised about the lawfulness of those practices. And that's really the focus of the paper. So, like I said, it's not about effectiveness. It's about that at a minimum, whatever is happening has to be lawful, and we need to have means of confirming that it is lawful. The concern about law enforcement intelligence is in part that to some extent it can fall between the cracks between oversight of police and oversight of intelligence agencies. Law enforcement oversight is often very focused on issues like police violence and corruption. It often relies on complaints, but for at least some of the technologies that are being used in the context of law enforcement intelligence, people might not even know what's happening behind the scenes. So who would complain if people don't know what's going on? So an example of that might be the use of facial recognition to identify suspects and so forth. It's not always clear that suspects will know that that's how or why they were identified in relation to a particular matter. And this sort of also reflects some of the complications around this. It's hard to have oversight of law enforcement intelligence because of the need for operational secrecy. So, there's a need for oversight that is able to be I suppose, because people won't always know what's happening, there's a need for oversight that is able to be initiated independently of a complaint and empowered to investigate behind the police veil, if you like, behind what might be able to be made public. It needs the expertise to understand some of the technologies, and it needs to be able to deal with both maverick and what I might call systemic non-compliance. And an example of sort of something like systemic non-compliance is some of what happened in some law enforcement agencies around the use of Clearview AI. So what does the oversight look like? Hold on. Why is they no longer scrolling? Okay, something wrong. There we go. Okay. It's quite complicated, and there's a lot of different moving parts, each of which focus, if you like, on different aspects of the broader problem. So you have, police standards units, which are internal, police oversight, which in some jurisdictions is some agency that has specific responsibility to oversee the police, and in other jurisdictions can be part of a broader public sector oversight. You have intelligence oversight, at least in Canada. You have privacy regulators, and then you have a whole raft of what I'm calling sort of indirect modes of accountability. So courts, for example, when they decide what evidence to admit, is making a decision that can have an impact on how police practices are regarded, because if ultimately you can't win cases because evidence is tainted in some way because of illegal practices, then that, if you like, it exercises some kind of constraint on illegal practices. In addition to the questions of admissibility, you've also got the relevance of warrants in some contexts, as well as the possibility of civil or criminal actions against police, again, as another oversight mechanism to control for illegality. You've got political entities. Again, this varies by jurisdiction, and they potentially can exercise some control over law enforcement intelligence. Hold on. You have, sorry, my son was calling me, always happens. You have also different kinds of what I'm calling horizontal accountability. So organisations that share information with police may be more reluctant to do so or more willing to do so based on the conduct of police. So that's another kind of pressure, if you like, not really directly oversight, but a form of accountability. But the fact that there are lots of entities involved doesn't necessarily mean that oversight is sufficient or comprehensive. In fact, the complexity can itself be problematic, particularly if it means there are contradictory signals. But the focus here, as I said at the start, is really looking at the powers of these different mechanisms and asking collectively, can they do the job? Methodologically, there was doctrinal analysis of arrangements for police intelligence oversight in each jurisdiction. There was empirical examination of the understandings of the oversight arrangements from the perspective of police in each country. And we had 60 interviews, and you can see how that was spread. And then we had to choose the jurisdictions, Australia, Canada and New Zealand, which was basically because of the similarities of political structures and the types of oversight, and yet enough variation that there were lessons that could be learnt. So, you've got differences, of course. New Zealand has one police force, Australia has a federal police and also state and territory police. Canada has even more local police, but there were nevertheless important similarities, at least in political structures and the kinds of oversight that was set up in the three jurisdictions. So, of course, another question, what do I mean by oversight? So I'm going to start with accountability and then sort of go down from there. So accountability refers to the right of the account holder to investigate and scrutinise the actions of the agent by seeking information and explanations, and the right to impose remedies and sanctions. There's different kinds of accountability. We can talk about political accountability, for example. I'm really focusing here on accountability for legal compliance. Of the 5 dimensions of accountability, and these are, who, for what, to whom, how, and according to what criteria, oversight really directs the attention on the to whom, although the other dimensions continue to play a role in understanding the nature of that oversight. Another important thing is I wasn't focusing on the rules themselves. So everyone has different privacy rules. Everyone has different rules that police in the different jurisdictions have to comply with. But I was really focusing not on the rules, but on the institutions that oversee compliance with those rules. So it doesn't matter to me that every jurisdiction, for example, has different privacy rules, which have different rules around how those agencies can handle data. What was important to me was, what are the mechanisms in each jurisdiction that ensure that the agencies are complying with the rules that apply in their own jurisdiction. So what I'm going to do now is just go through the different my computer screen's gone crazy. Okay, just go through the different mechanisms and some of what I found about each of those in each of the jurisdictions. So starting with internal oversight, and I've put up a quote there, which actually came from Canada. But it was someone who had worked previously in Australia, so it was quite interesting in highlighting some of the differences between those jurisdictions. And the point they're making really is that there's a lot of auditing that happens in Australia, and for that matter also in New Zealand, but not in Canada. So that's sort of one example of a sort of oversight process that's clearer in 2 of the jurisdictions and the third, and the kind of cross-learning that I was trying to get to in the paper. So professional standards units more broadly are seen as very important and are certainly the most likely to get police cooperation, but obviously do not replace the need for independent oversight outside the agency itself. So in addition to the mechanism I spoke about, the auditing one, we found a number of other important mechanisms that were applied in the context of internal oversight in different jurisdictions, controlling access rules, giving online warnings about what data could and couldn't be accessed, internal permission processes before you could access data, lockdown folders, and so forth. We had one comment from New Zealand, and to quote, "But there are always ways if you know how." So there's ways around everything potentially, but nevertheless, these were seen as important and certainly setting a set of expectations within an agency. They're also, I should say, better at catching a sort of a bad cop, if you like, someone who's doing something wrong, who's looking up information that they shouldn't be, or doing something inappropriate, than it is at dealing with some of the more systemic problems of, programs operating where the program itself raised concerns. But nevertheless, an important mechanism, and certainly was perhaps one of the most important ones for people in the interviews in talking about their understanding of what oversight was, because it's the most immediately present. So next, looking at police oversight, by which I mean oversight that focuses on police agencies as such, either because it's an oversight body that just looks at police, or because it might look at a broader range of bodies, like, up to the whole public service. In this particular case, what we found is that there were a number of problems with this, at least in some jurisdictions. So it's quite complex to go into the full jurisdiction by jurisdiction analysis, because in Canada there are many jurisdictions, and in Australia there are still a lot of jurisdictions. But just to give you an overview of some of the issues. One problem that was the case in a lot of jurisdictions is that you required a complaint to initiate the process. In other words, there was no ability from the oversight body to sort of initiate a process or an investigation itself, and that is quite limiting. It's limiting for a number of reasons. I can use an example actually from New South Wales, which is it was actually based on a media report where it was found that they have suburb-based targets for search warrants in New South Wales. Now, individuals, when a search warrant is being served on them, don't necessarily have a view on the fact that there are suburb-based targets, or how that might interact on, the fact that there is a search warrant currently being executed on their house, or how the police are interacting with them in the context of the exercise of that warrant. So the program, which is the suburb-based targets for search warrants, leave aside the legality of the specifics of that program for a minute, but if there are concerns about that program, my point is none of the people, no one would know to make a complaint about it, because it's not necessarily immediately apparent that that program even exists to the people who are interacting with police. And in that sense, it differs quite a bit from something like police violence or police rudeness or whatever, which is more likely to generate a complaint because the person is aware that, there is violence, or that they've been, sworn out or whatever it might be, that would lead to them knowing something is wrong and then exercising their right to complain. Now, in Canada, at the federal level, and like I said, I'm not going to go through all the jurisdictions, it's not limited to complaint, and there have been own motion investigations on issues like bias-free policing, which in particular has given them the opportunity to look at some of the intelligence practices and the extent to which that might have differential impact on different racial groups. But there are still problems. So the next problem here is that in some contexts, you can't make complaints about civilian staff inside police, only about uniformed officers. And in a lot of police agencies, and this is particularly the case in Canada, but not exclusively, it is civilian staff that are acting in intelligence roles. So if your concern is about police intelligence practices, that is a limitation based on how oversight works inside the legislation. So the other thing to note is that the bodies varied in their investigatory powers. Some bodies had more powers than others, and so we did a comparison on that. What came out from the interviews on this is that intelligence was very rarely the subject of investigation by the agencies that oversee police more broadly. The focus was on police violence, deaths in custody, corruption, and so forth. And like I said, the reasons for that seem to me to be a combination of things. It sometimes is jurisdictional, like the fact that intelligence practices are less likely to come up in complaints, or the fact that you can't make a complaint about activities of civilians. And sometimes it just possibly, that's just the practice, that happens to be the focus of the bodies doing oversight, or that happens to be in that particular place the nature of the complaints that are coming in. So police oversight, in short, doesn't look like it's necessarily very good for overseeing police intelligence. The next one is, well, okay, if police oversight's not doing it, what about intelligence oversight? Because obviously we have in Australia, bodies like the IGIS that have a role in regulating ASIO and other intelligence agencies, and maybe that could be extended into the intelligence function of law enforcement agencies. And that's certainly something Canada's now done. So that the relevant intelligence oversight includes any activities that relate to national security or intelligence undertaken by the Royal Canadian Mounted Police, which is their federal police agency, their national one. But that is only Canada that has done that. Australia looked at that for a little while, but it actually decided not to expand IGIS to include the AFP, with a very narrow and specific exception. South Australia is absolutely fascinating as a tiny case study on this, because it has sort of all sorts of rules around intelligence in law enforcement. and the limited circumstances in which that can happen. But then it has a very narrow definition of what law enforcement intelligence is, and its annual review states that it doesn't do any of it at all, which might just be because of the nature of the definition it imposes. So it's perhaps a sign that if you over-regulate, nothing will get called intelligence because everyone wants to fall outside the box. But nevertheless, it's a slightly interesting case study there. There was mixed views in interviews on whether intelligence oversight would be useful. You have on the screen an example of one of the New Zealand interviewees who thought that it would make sense to look at intelligence oversight across the board, so including law enforcement intelligence with the intelligence agencies for that purpose. Privacy oversight. This was perhaps most active in Canada. The Canadian Privacy Commissioner had been very active in this, conducting audits and so forth, exercising powers to demand information. It had a recent report on Clearview AI, which found that the police in Canada did contravene their Privacy Act by collecting information through a contract with a private company that was itself collecting information unlawfully, and so even though it wasn't itself doing the unlawful things, it was the company that was doing the unlawful things. What the Privacy Commissioner said in Canada was that law enforcement was acting outside its legal authority by relying on data that had been ultimately collected unlawfully. But even in Canada, where this was really quite active, police sometimes withhold information from privacy commissioners, including in the context and this was sort of one of the things that even mentioned in that Clearview AI report. You could sort of see some of the challenges of getting the information out of law enforcement in terms of what it was doing and what it knew at particular times and so forth. Privacy commissioners generally lack power to directly access internal documents. So where you've got intelligence oversight, you've got an agency like it can just walk into ASIO and say, open your files and I want to read all of them. Whereas that's not something that, for example, privacy commissioners can do in any jurisdiction, including Canada. It gets even worse in Australia. At the federal level, we obviously have different things at all the different states and territories. But at federal level, OAIC is not only unresourced, but it actually cannot obtain documents where this would, and I quote, prejudice the effectiveness of the operational methods or investigative practices or techniques of agencies responsible for the enforcement of the criminal law. In other words, it's going to find it very hard to do something similar to what the Canadian Privacy Commissioner did in finding out information about how the agency were using Clearview AI. So that's that. There's some more complexity here, but I'm going to skip over it a little bit to move on because it doesn't play a huge role, at least in Australia. There's also a bunch of ad hoc stuff that happens. One kind of ad hoc thing is the sort of Royal Commissions of inquiry, and there've been several of these that have involved law enforcement intelligence practices in different jurisdictions. So there's always that kind of a possibility that, you wait till you think something's wrong and then you call a commission of inquiry. But that kind of thing isn't very effective at picking up the kind of routine problems, the sort of day-to-day decisions and programs that are run that might, for example, where there might be legal issues in the implementation of those. AI ethics and governance is another sort of really interesting space. Government tends to, Australian government certainly has sort of be very, pontificating about AI ethics. You can only use certain kinds, these kinds of tools when you're doing good and when you're accountable and when you're not biased against anybody, et cetera, et cetera. But we haven't seen a lot of that actually having any impact at all on practice. And that's not just law enforcement, that's across government generally. To my mind, it's sort of one of those, very high-worded statements that actually kind of doesn't change what anyone does anywhere, as best as I can tell, because there's no enforcement mechanism. There's no way of even measuring against it and reporting on it. So it's sort of a bit meaningless. Going into some of the sort of less direct forms of oversight. So this is not so much oversight bodies, which have an oversight function per se, but the other things I spoke about at the start, where there's a kind of a sort of check and balance through another mechanism. We looked at sort of the role of the judiciary, and we did that through several things. We looked at evidence, warrants, and also actions against police. I'll let you read the quotes yourselves, but broadly, evidence. Canadian courts were more willing generally to exclude evidence based on broad problems like discriminatory police practices through the use of predictive policing type mechanisms where you might be discriminating against different racial groups and the way those are implemented. In that kind of a situation, Canadian courts would actually exclude the evidence that was, even if you stopped a person, if you stopped and frisked and you were doing that in a racially biased way, then the evidence you collect in that stop and frisk might not be able to be presented as evidence in court. So if a predictive policing program were to exhibit racial bias, there's a reasonable likelihood in Canada that evidence collected through over-policing of racialised neighbourhoods or individuals would be excluded. The challenge, of course, is that would the defendant even know or be able to bring in evidence to object to the evidence that that was in fact the case. It's also the limitation of the evidence sort of balance, if you like, is that not everything goes into evidence. A lot of police intelligence doesn't actually end up with someone being prosecuted in a court and evidence being brought against them for all sorts of reasons, everything from plea bargains, through to the fact that a lot of what happens might just be the kind of stop and frisk stuff or the knocking on doors stuff or the sort of other kind of background stuff that occurs to sort of prevent crime, rather than the kind of stuff that actually leads to cases being brought. Warrants is closely linked to the evidence point. So in some contexts, you need to get a warrant in advance if you want the evidence at the end of the day to be admissible. But again, that's true in some contexts, but you can certainly many statutory schemes where you don't need warrants, including access to telecommunications metadata in the Australian context. So you can do quite a bit without warrants, but where they're there, they are another mechanism. Where the legality of the proposed police action can be checked before it's done. Actions against police is another theoretical possibility where courts could exercise control over this, but they're rare, and where they happen, they're really successful. And there's a whole scholarship explaining why. But yes, that's not necessarily a great mechanism. So political oversight, yes. It can be somewhat limited. I won't go through the legalities of that, but ultimately there are limits. There are both limits on the political control that can be exercised over police because there's a measure of independence required, but there's also questions about the willingness of these political mechanisms to look at these, sort of specific issues. Nevertheless, it is true that political oversight mechanisms can require legal accountability via political means, through responsible ministers, through parliamentary committees where they have a relevant focus or role, and through police service boards, which is a particular Canadian mechanism. Horizontal, this one came up quite a lot in the interviews, and I've put some quotes on the screen, which is essentially the idea that there's a trust issue and people will only share their information with police and with law enforcement intelligence where they trust you. And so there's quite a lot that agencies are very conscious of when getting data from external agencies in terms of how they handle that data and the sort of, good and proper processes that they exercise around that data. But I don't know, I'll just give you all a sec to read that. I think me reading it's perhaps a little boring. Okay, one of the things I found most interesting in doing this research was the role of the media. So the media not only played a huge role, as you can see on the screen, in terms of how the law enforcement intelligence officers and managers themselves perceived accountability, in other words, an oversight. In other words, for them, the fact that it could be on the front page of the paper, etc., played a really big role in holding them to account, that the media and the risk of media exposure of something bad. The Daily Telegraph rule, as it was described by one, did play a really a sort of strong oversight role in terms of how they thought about it in their own practices. I actually found that both good in the sense that, yes, the media is playing an important role here, but also somewhat problematic because it sort of highlighted to me the lack of other oversight mechanisms. So in Australia, for example, if you look at the use of Clearview AI and you think about, well, Clearview AI was acting illegally in terms of its own practices in collecting data, but many law enforcement agencies, including in Australia, were using this for facial recognition. Why is it that it was the media that exposed that and queried that and led to that kind of, being, challenged, and I think ultimately in many places shut down, and not the normal oversight mechanisms that we would expect to look at practices in law enforcement and oversee those practices and ensure that they meet community standards and legal requirements and so forth. In other words, the fact that all of these issues seem to come up in the media, I think is good, but it's also, I think, highlighting that that it's not happening through the mechanisms that were put in place for that to occur. Part of this is, I think, that again, it's the transparency problem and what people are not necessarily making complaints about things that they don't know are happening. If you think about something like a predictive policing program or a facial recognition program, there's lots of sort of legal questions that come up, as well as just community expectation questions that come up in those programs. Ideally, what you want is a sort of ex ante process in a way, rather than what's happening now, which is that these things are implemented and then, like I said, largely being called out, if at all, by the media. Most of the information that is made public around law enforcement intelligence is very general, it's statistical, and it doesn't include sufficient information that would enable anyone to know whether, there's any sort of, to be able to assess the legality of the different programs that are being used. So that I suppose is why this was somewhat sort of a mixed blessing in terms of the role of the media. So the recommendations we made, there's the one I already mentioned about Canadian agencies looking to do auditing in terms of access to databases and in using that auditing to ensure that people are only accessing information that they ought to be for the purposes of an investigation in accordance with, in Australia, it would be the Privacy Act at the federal level and the different pieces of legislation at state and territory level, but having an auditing mechanism that actually picks up situations where people are accessing information that's not relevant to the investigations they're doing. I think there's opportunities for ongoing interagency learning about different compliance by design approaches to information systems used in law enforcement. It seems that different agencies are doing quite different things around, issuing warnings, limited, requiring authentication before you could access, requiring supervisor permission to access, how they were doing the auditing processes and so forth. And it could be good, I think, to have a conversation among agencies that cooperate in all sorts of ways about how they can learn from what the different ones are doing more broadly. Closing gaps in the jurisdiction of police oversight with respect to intelligence. And this is essentially, and what needs to be fixed differed by jurisdiction, but for any jurisdiction, what I think they should be doing is ensuring the existence of an oversight body with powers of investigation in the absence of complaints that incorporates intelligence practices as not confined to sworn officers. And how that's done, I'm a bit more neutral on, whether that's done through the agency currently overseeing police or whether that's done by linking it with intelligence oversight or another appropriately empowered body is every jurisdiction looks different already, but I do think that element is important and something that existing practices can be measured against. Privacy oversight bodies, so this is sort of privacy commissioners, I think also need investigatory powers and resources if they're to play a role in oversight of police intelligence. It's a limited role because it only relates to the legality of data collection and processing, but it's nevertheless an important part of what intelligence does, and so that can play an important role, but isn't necessarily playing, at least outside of Canada, the role that it might be able to. The next point was, while political oversight is diverse, information should be available to relevant political entities to help them understand the intelligence context, make them aware of intelligence practices, and have resources to consider the legality of those practices. The information in the reporting that's currently going to parliaments and so forth is absolutely so bare as to be almost useless. So there needs to be something at least rich enough that they would know, for example, that predictive policing is being used, or particular facial recognition tools are being used, or that social media analytics is being used to identify suspects and so forth. So some information that actually talks about intelligence practices and intelligence programs, so that gets political oversight rather than simply waiting for the media to write a story about it, which feeds more broadly into transparency, which is transparency to the extent it does not compromise operational effectiveness is crucial in ensuring public accountability. So in my mind, if there's going to be a decision to use some of these tools that are coming out in this context, those decisions should be made openly and ideally in the context of consultation with communities around how any limitations of those tools, including things like the potential for racial bias, will be managed in those programs. And that, I cannot see an sort of operational effectiveness style reason for not being upfront, with the broader public, if you like, for that kind of public facing accountability, but perhaps via political accountability for the operation of those kinds of programs at a high level, not talking about who's been identified or anything like that, but at a very high level, the fact that those kinds of things are going to be used, I think, should be the subject of more sort of public accountability. So overall, what I found, accountability mechanisms in the jurisdiction studied are a patchwork with internal professional standards units operating alongside independent bodies, exercising jurisdiction, whether that's over police agencies specifically or public sector agencies more broadly, over intelligence activities of the agencies, or with respect to privacy laws specifically. In addition, there were important oversight functions performed by judges, ministers, police service boards, parliamentary committees and other agencies, as well as ad hoc processes such as public inquiries and royal commissions that play a crucial role on the issues they deal with, but lack permanent jurisdiction, so can't really be relied on for oversight. Where information is available, and sometimes filtered through the media, there can also be a measure of public accountability. But as I mentioned right at the beginning, the complex web itself provides its own challenges. One Australian participant said, how do we make sure that the various oversight agencies in that jurisdiction they were talking about don't crash up against each other? The answer is there isn't really a mechanism for that right now. But while a single sort of oversight agency for law enforcement intelligence might be simpler from that narrow perspective, the various components collectively cover substantial ground, and with some, tweaking, could do this quite well. So the question is not, in my mind, whether the pieces, the pieces fit together into sort of a perfect framework, but how can we sort of make sure that collectively, taking all of the different pieces, there is jurisdiction, function, power and expertise to oversee law enforcement intelligence. It doesn't need to be the same in different jurisdictions, but there's a lot the jurisdictions can learn from each other. And that they might be able to pick up on particular things, and hopefully that gives you some examples of the kind of thing I was recommending. So that's it. Thank you very much, and I look forward to your questions.
Wonderful. Thanks, Lyria. And if you can enter your questions into chat, I might start, so I suppose it's my privilege to start with my own question. So your talk, it was fantastic, and it really it brought out a related issue that I've been thinking about, and that's the extent to which the proprietary nature of a lot of this technology limits that transparency, or limits the ability to be transparent. And I know recently, at least within the risk assessment and predictive policing sort of field, there's been a more and more discussion around the use of open source technology. So that's where, for those of you in the audience as well, the code is kind of made available to the public, and potentially the data is made available to the public. So the results of particular technology, so at a broad level, so you're not identifying anyone. What do you think the viability of using open source technology is for law enforcement, and what are the implications that you think that might have for police oversight?
So I think the need for it might be variable depending on the context. So once you say we've got good accountability mechanisms in place, hopefully those mechanisms can help contribute to the debate on what actually needs to be white boxed and what is fine as a black box. So to take a really simple example, if you consider something like facial recognition technology, I don't really need to see the code. I probably wouldn't even be able to read it personally, but even if I had experts who could read it for me and say, this measures nose gaps and cheek distances and whatever else, eye gaps and I don't know, whatever else it might do, that's not actually really going to tell me very much, either about, whether I should be doing it, whether it's legal to do it, whether I can access particular images when I try to compare images to things. The code isn't really the driver there of the questions that we want to ask about what's going on. So I would be, less concerned about that being, black box, proprietary, whatever, and more concerned about having a place and a mechanism that asks the questions that need to be asked before that kind of thing is used in particular ways. On the other hand, I think predictive policing raises very different issues. So if you're doing something like predictive policing, I think it really does matter how it works, because by knowing how it works, you can actually work out, hold on a second. So if historically police have been focusing on particular neighbourhoods with respect to particular kind of crimes, this is just going to keep that loop running and not actually give us a broad perspective on where our focus should rightly lie. So for that kind of tool, yes, I think it would be open to through in a sort of proper good accountability framework, but when those questions are being asked back and forth between the oversight and law enforcement, to say, you're using how do you answer these questions? How do you know if this is sending you to racialized neighborhoods, or what are you doing? And it might be there are answers to that, right? It might be to say, well, we are using a black box tool, but we can, we understand at a high level how that tool's designed. We've tested it, we've measured it for racial disparity, we've done, and maybe then you could say, okay, so while it might be more useful to understand how it works, you've done enough evaluation of the kinds of problems that can arise in these kind of systems that, okay, it's fine. It's not racially discriminatory, or whatever the concern might be. So I think it depends. So I love open source, but I'm not sure I want to kind of go and say police have to use open source. What I'd rather say is, I think there needs to be oversight. I think there needs to be accountability, including legal accountability, as well as all the other things about, if community acceptability, all that I wasn't looking at specifically in this paper, but are also really important questions. And I think that once those processes are in place, and this is part of normal practice, then those questions will be asked. And if they're not adequately answered and there are consequences, some of that will feed back into better processes that might include the adoption of more open source systems.
Yeah. Okay, wonderful. Thanks for that. Okay, we have our first question. So, do you anticipate that the sometimes fraught relationship between intelligence practitioners and operational police, which can have cultural as well as systemic components, also impacts on internal oversight, as notionally would occur for a normal policing function?
I didn't look at that specifically, but it's a really good question. In this broader project that we're doing, there has been a lot more examination of that, of the sort of fraught relationship, if you like, between intelligence practices and operational police. And Carrie Sanders in Canada is doing a lot of work on those aspects of it from different parts of the interview, because the interviews didn't just cover off on this. But it's I didn't look at that specifically, but I always love the questions you get after you've collected and analysed interview data. It's like, gee, should have added a question. Should have looked at that specifically, but maybe for next time.
Okay, we have our second question. Were the recommendations tabled to relevant organisations?
So yes, there was a report prepared that went out to law enforcement agencies. I have no knowledge as to whether that was used or not, but there was a sort of very much a report focused on telling law enforcement what we thought. And that also differentiated much more clearly in terms of which agencies needed to do what. But it is also an academic exercise. So the paper itself, covers all of it. But no, there was also a more of a sort of simplified, leave out all the academic citations and boring parts, and going much more directly to the recommendations and sort of explaining those.
And have you had any feedback so far?
I'd have to check with the whole team, because the sort of direct engagement with law enforcement, and it wasn't only on this issue, I should say. So the reports back were on the whole broader project, which was being led by Carrie Sanders. So she had more of that direct engagement. I know she had, some positive signs from parts of Canada, but I'd have to ask, more broadly whether she'd heard back from them in anything specifically related to this too, bearing in mind that what they were getting was the whole project, including not just this element.
Okay, all right, thank you. Wonderful. I don't think we have. Do we have any other questions? No. All right, wonderful. Well, Lyria, thank you very much for joining us today and for presenting on the topic. It was really, really fascinating, and it's given me at least a lot to think about. And I'd like to thank everyone for attending as well, and I hope you enjoyed it as much as I did. Please join us next month on the 20th. We'll be sending out another flyer for Anna Charlton, who will be presenting on the sentencing of stalking offences. Okay.
Well, thank you very much for having me, and thank you all for coming.
All right. By the way, this will be recorded, so look out on our YouTube channel for this video to be presented. Okay, wonderful. Okay.